I never imagined that a simple wooden fence would become the biggest battle of my life. But when I found that HOA violation notice taped to my front door on a Tuesday morning in March, I knew my peaceful existence in Riverside, California, was about to get complicated. My name is Jack Lawrence, and I had just bought my dream home 6 months earlier. The property was a charming 1940s bungalow on Magnolia Street, complete with original hardwood floors, a stone fireplace, and a beautiful hand-built wooden fence that wrapped around the backyard. The fence was one of the things that had sold me on the place. It had this rustic, weathered charm that you just cannot replicate with modern materials. The wood had aged to a silvery gray, and the craftsmanship was impeccable, with mortise and tenon joints that showed the work of someone who really knew what they were doing. The notice was printed on official-looking letterhead from the Riverside Meadows Homeowner Association. I stood there in my bathrobe, coffee mug in hand, reading the words with growing disbelief. Violation notice. Unapproved fence structure. Your property at 847 Magnolia Street contains a fence that does not meet current HOA standards for color, height, and material composition. You have 30 days to remove or replace this structure or face fines of $500 per day. $500 per day. I read that line 3 times to make sure I was not hallucinating. I had never even heard of the Riverside Meadows HOA before that moment. When I bought the house, nobody mentioned anything about a homeowner association. I checked all my closing documents, my title insurance, everything. There was no mention of HOA fees, rules, or regulations. I would have remembered something like that because I had specifically avoided looking at homes in HOA communities. I valued my independence and did not want some neighborhood committee telling me what color I could paint my shutters. I called the number on the notice immediately. A woman answered on the 3rd ring with a voice that could cut glass. Riverside Meadows Homeowner Association. This is Barbara speaking. Hi, my name is Jack Lawrence. I just received a violation notice about my fence, and I think there has been some kind of mistake. No mistake, Mr. Lawrence. Your fence is in clear violation of our community standards. But I was not aware that my property was even part of an HOA. There was nothing in my purchase documents about it. There was a pause, and I could hear papers rustling. According to our records, all properties on Magnolia Street between Oak Avenue and Pine Boulevard are part of our association. The HOA was established in 2019, and all homeowners were notified at that time. I only bought my house last September, and like I said, there was nothing about an HOA in any of my paperwork. Barbara's voice took on a tone of practiced patience, the kind that adults use when explaining something to a stubborn child. Well, Mr. Lawrence, ignorance of the rules does not exempt you from following them. The fence needs to be brought into compliance within 30 days, or the fines will begin accruing. This fence has been here since before I bought the house. It was here when I did the inspection. It is part of the property. That may be, but it does not meet our current standards. The wood is weathered and unsightly. It exceeds our 6-foot height restriction in some areas, and the gray color is not on our approved palette. We require all fences to be painted in colors from our approved list or constructed of approved vinyl materials. I felt my blood pressure rising. You want me to tear down a perfectly good fence and build a new one? Do you have any idea how much that would cost? Our standards exist to maintain property values for everyone in the community. Mr. Lawrence, I suggest you get started on the repairs or replacement right away. The clock is ticking. She hung up before I could respond. I spent the rest of that day fuming and researching. I pulled up every document from my home purchase, searching for any mention of an HOA. Nothing. I called my real estate agent, Marcus, who had helped me buy the place. He was as surprised as I was. Jack, I swear there was no HOA when we closed on that property. I specifically remember checking because you mentioned you did not want to deal with one. Let me make some calls and see what I can find out. Next, I drove down to the county recorder's office to pull the property records. The clerk, a helpful woman in her 50s named Dorothy, helped me dig through the files. We found the deed to my property, which made no mention of any HOA covenants or restrictions. We also found records showing that my house had been built in 1947 by a man named Robert Fletcher, who had lived there until 1983. This is interesting, Dorothy said, adjusting her reading glasses as she examined a faded document. According to this building permit from 1947, the fence around your property was constructed at the same time as the house. It is listed right here in the original plans. My heart started beating faster. So the fence has been there since 1947. According to these records, yes. And look at this. She pulled out another document. This is the filing for the Riverside Meadows HOA. It was not established until May 2019, so your fence predates the HOA by more than 70 years. I felt a rush of vindication. Can I get copies of all these documents? Absolutely. Give me about 20 minutes. I left the recorder's office with a thick folder of copies, including the original 1947 building permit that clearly showed the fence as part of the initial construction, photographs from the historical archives showing my house with the fence already in place, and the 2019 HOA filing documents. I felt like I had just found buried treasure. The next morning, I called the HOA number again. Barbara answered, and I could hear the annoyance in her voice when I identified myself. Mr. Lawrence, if you are calling to argue about the violation, I should inform you that the board's decision is final. I'm calling to inform you that I have documentation proving that my fence was built in 1947, more than 70 years before your HOA even existed. It is part of the original construction of the house. There was a long pause. That is irrelevant. The fence currently does not meet our standards. How can it be irrelevant? The fence existed long before your organization had any authority over this property. Mr. Lawrence, when the HOA was established, all properties within the designated boundaries became subject to our covenants and restrictions. Your fence needs to comply with current standards, regardless of when it was built. I would like to speak to someone on the board about this. The board meets once a month. The next meeting is not until April 15th. That is almost a month away. My 30-day deadline would have already passed by then. Then I suggest you begin work on bringing the fence into compliance. Her tone made it clear the conversation was over. I hung up and immediately started looking for a lawyer. I was not about to let some power-hungry HOA bully me into tearing down a piece of history. After calling several attorneys who either did not handle HOA disputes or wanted retainers I could not afford, I finally connected with a lawyer named Gregory Chen, who specialized in property law and HOA cases. We met at his office that afternoon. Gregory was in his early 40s, with sharp eyes and an easy manner that put me at ease immediately. I spread out all my documents on his desk, and he examined them carefully, making notes on a legal pad. "This is actually quite interesting," he said after about 20 minutes. "You have very solid documentation here. The fence predates the HOA by a significant margin, and there is a legal principle that might work in your favor. It is called grandfathering, or sometimes non-conforming use. Essentially, if a structure or use existed before new regulations were put in place, it can often be allowed to continue even if it does not meet the new standards. So, I do not have to tear down my fence? It is not that simple. We will need to look at exactly how your property became part of the HOA. You said there was nothing in your purchase documents about it? Nothing at all. Gregory leaned back in his chair, tapping his pen against his chin. That is unusual. Normally, HOA membership runs with the land, meaning it automatically transfers with the property. But there should have been disclosure in your purchase documents. Let me do some research into the specific laws in California and the terms of this particular HOA. I will also need to see the HOA's covenants, conditions, and restrictions, the CCRs. How do I get those? They should be on file with the county, but I will request a copy directly from the HOA as well. In the meantime, do not do anything to the fence, do not start any work on it, and do not tear it down. We want to preserve the status quo while we figure this out. I left his office feeling slightly better, but still anxious. The 30-day clock was ticking, and I had no idea what would happen when it ran out. Over the next week, I tried to go about my normal life, but the fence situation hung over everything. I worked as a software developer from home, and I found myself constantly distracted, staring out the window at the fence that had become the center of my universe. It looked the same as always, solid and weathered and beautiful in its own way. I could not understand why anyone would want to replace it with some generic vinyl monstrosity. Marcus, my real estate agent, called me with some disturbing news. "Jack, I have been digging into this HOA situation and I found something weird. The HOA boundaries were amended in 2023 to include a few additional streets, including yours. Originally, when it was founded in 2019, Magnolia Street was not part of it." Wait, what? So my property was not even in the HOA when it was first created? Exactly. They expanded their boundaries 4 years later. And here is the really weird part. I cannot find any record of the proper legal process being followed for that expansion. Normally, when an HOA expands, they need to get approval from the affected property owners, or at least notify them. I talked to some of your neighbors, and none of them remember being notified or asked to vote on joining an HOA. This was getting more complicated by the minute. Did you tell Gregory about this? I'm sending him everything I found right now. 3 days before my 30-day deadline, I received another notice from the HOA. This one was even more threatening. Final notice. Your fence remains in violation of community standards. You have 3 days to begin remediation or face fines of $500 per day, plus potential legal action to compel compliance. The board has also voted to place a lien on your property for unpaid violation fines. A lien on my property? I had not even been fined yet, and they were already talking about liens? I called Gregory immediately, and he told me to come to his office right away. When I arrived, he had documents spread across his entire desk and looked like he had not slept in days. "Jack, this is bigger than we thought. I have been going through the HOA's formation documents and their 2023 boundary expansion, and there are some serious legal problems with what they did." He showed me a map highlighting the original HOA boundaries from 2019 and then the expanded boundaries from 2023. When they expanded, they were required by California law to follow a specific process. They needed to notify all affected property owners, hold a vote, and get approval from a certain percentage of owners. According to everything I can find, they did none of that. They just unilaterally decided to expand their boundaries and started acting like they had authority over properties that never agreed to join. Is that legal? Absolutely not. But it gets worse. I looked into the background of the HOA board members. The president is a woman named Karen Whitmore, and she has a history of this kind of thing. She was previously on the board of 2 other HOAs, and both times she was involved in disputes over overreach and improper fines. In one case, she was actually sued successfully by a homeowner who proved the HOA had violated state law. So what do? We fight back. I am going to file a lawsuit challenging the HOA's authority over your property. We will argue that the boundary expansion was illegal, that you never consented to join the HOA, and that even if the HOA did have authority, your fence is a non-conforming use that should be grandfathered in. We will also seek an injunction to prevent them from fining you while the case is pending. How long will this take? Gregory grimaced. HOA cases can drag on for months or even years, but given the clear legal violations here, I am hoping we can get this resolved relatively quickly. The problem is that even if we win, the HOA could appeal, and then we are back in it for the long haul. What about the other neighbors? If the HOA illegally expanded to include my street, does that mean everyone on Magnolia Street is in the same boat? Potentially, yes. Have you talked to any of them about this? I shook my head. I have only lived here 6 months. I know a few people to wave to, but that's about it. It might be worth reaching out. If we can get multiple homeowners to join the lawsuit, it will strengthen our case and split the legal costs. That evening, I walked up and down Magnolia Street, knocking on doors and introducing myself properly for the first time. Most people were friendly but busy, and several were not home. But I did connect with a few neighbors who were very interested in what I had to say. One of them was a retired school teacher named Helen Norton, who lived 3 houses down. She invited me in for coffee and listened intently as I explained the situation. I knew something was fishy about that HOA, she said, shaking her head. I have lived on this street for 32 years, and nobody said anything about an HOA until about 3 years ago when I started getting these official-looking letters telling me I needed to repaint my house and trim my hedges. I just ignored them, because I figured they did not have any real authority. Have they tried to fine you? They threatened to, but nothing ever came of it. I think they were focusing on newer residents who might not know any better. I met with 2 other neighbors that evening who had similar stories. One was a young couple, Tom and Lisa Peterson, who had received violation notices about their mailbox. The other was an elderly man named Frank Morrison, who had been threatened with fines over his front lawn, which the HOA claimed was not green enough. The next day, I brought Gregory a list of neighbors who were interested in joining the lawsuit. He was thrilled. This is perfect. A class action lawsuit will carry a lot more weight than an individual complaint. Let me reach out to these people and see who wants to formally join. The day my 30-day deadline expired, I woke up feeling sick to my stomach. I half expected to find bailiffs on my doorstep, ready to start tearing down my fence. Instead, I found another notice from the HOA, this one stating that I was now being fined $500 per day and that the total would be due immediately. If I did not pay, they would place a lien on my property and eventually could force a sale to recover their costs. Gregory filed our lawsuit that same day. Along with me, 4 other homeowners on Magnolia Street had agreed to join as plaintiffs. The lawsuit challenged the legality of the HOA's boundary expansion, demanded proof that proper procedures were followed, and sought damages for harassment and emotional distress. The local newspaper, the Riverside Press Enterprise, got wind of the story and sent a reporter to interview me. Her name was Amanda Torres, and she was sharp and thorough. She spent 2 hours at my house examining the fence, photographing the historical documents, and asking detailed questions about the HOA's actions. The article ran 3 days later on the front page of the local section. Historic Fence Becomes Center of HOA Battle, the headline read. The piece laid out the whole situation, including the questionable expansion of the HOA boundaries and Karen Whitmore's history of similar disputes. The response was immediate and overwhelming. My phone started ringing off the hook with neighbors I had never met, some from streets beyond Magnolia, all telling me they had experienced similar problems with the Riverside Meadows HOA. Some had paid fines they now realized might have been illegal. Others had made costly changes to their properties under threat of liens and lawsuits. Gregory was ecstatic. This is exactly what we needed. The more evidence we have of a pattern of behavior, the stronger our case becomes. A week after the article ran, I received a certified letter from Karen Whitmore herself, in her capacity as HOA president. The letter was dripping with condescension and threatened even more severe action if I did not immediately comply with the fence violation. She also accused me of damaging the HOA's reputation by talking to the press and suggested that I could be sued for defamation. Gregory laughed when I showed him the letter. This is pure bluster. She is trying to intimidate you because the article hurt her, but everything you told the reporter was factual and backed up by documents. She has no case for defamation. The HOA's response to our lawsuit arrived 2 weeks later. Their lawyer, a firm out of Los Angeles called Harding & Associates, filed a motion to dismiss, arguing that the court had no jurisdiction over internal HOA matters and that we had failed to exhaust administrative remedies by not attending HOA board meetings to present our case. Gregory shook his head as he read through the motion. This is a standard delaying tactic. They are hoping you will get frustrated and give up. But we have strong grounds to oppose this. The illegal expansion of boundaries is not an internal matter. It is a violation of state law. The court scheduled a hearing on the motion to dismiss for late May. In the meantime, the HOA continued to add $500 per day to my supposed debt. By my calculation, I was now allegedly on the hook for over $15,000. The stress was beginning to take its toll. I was not sleeping well, and I found it hard to concentrate on work. Every time I looked at my beautiful fence, instead of feeling pride, I felt anxiety. I started having dreams about bulldozers and wrecking crews. Helen Norton became an unexpected source of support. She would stop by every few days to check on me, bringing cookies or casseroles and offering encouragement. "Do not let those bullies win," she would say. "You are doing the right thing, not just for yourself, but for everyone on this street." The preliminary hearing arrived on May 20th. Gregory and I arrived at the Riverside County Superior Court early, both dressed in suits. The courtroom was smaller than I expected, with wooden benches and harsh fluorescent lighting. The HOA was represented by a lawyer named Richard Harding, a man in his 60s with silver hair and an expensive suit. Karen Whitmore sat behind him in the gallery, her arms crossed, glaring at me with unconcealed hostility. She was exactly what I had pictured. A woman in her late 40s with short blonde hair, styled in a bob, pearls, and an expression that suggested she had just smelled something unpleasant. Judge Patricia Martinez presided. She was a no-nonsense woman in her 50s who had a reputation for being fair but impatient with legal games. Harding argued his motion to dismiss, claiming that HOA disputes should be handled internally and that the courts should not interfere with how private organizations govern themselves. He made it sound like we were trying to undermine the entire concept of community standards. When it was Gregory's turn, he systematically dismantled every argument. He presented evidence that the HOA had illegally expanded its boundaries without proper notice or consent, showed that I had never agreed to join the HOA, and demonstrated that the fence was a historical structure that predated the HOA by 72 years. Your Honor, this is not a case of a homeowner simply disagreeing with reasonable HOA rules, Gregory said. This is a case of an organization that has exceeded its legal authority and is now attempting to extract thousands of dollars in fines for a violation that does not exist. The plaintiff's fence is a piece of history, and the HOA has no right to demand its removal or alteration. Judge Martinez asked several pointed questions about the boundary expansion process and the documentation of proper procedures. Harding fumbled through his responses, clearly not prepared for such specific inquiries. After about 90 minutes, Judge Martinez made her ruling. I am denying the motion to dismiss. The plaintiffs have raised serious questions about the legality of the HOA's actions, and these issues require a full hearing. Furthermore, I am granting a preliminary injunction preventing the HOA from assessing any further fines against the plaintiffs until this matter is resolved. The existing fines are also stayed pending the outcome of this case. I almost shouted with relief. Gregory squeezed my shoulder, and I could see Karen Whitmore's face turn red as she whispered furiously to her lawyer. As we left the courtroom, Karen confronted us in the hallway. This is not over, Mr. Lawrence. You are destroying property values for everyone in the community with your selfishness. My fence has been standing for over 70 years without hurting anybody's property values, I replied calmly. Maybe you should focus on following the law instead of harassing homeowners. How dare you, she sputtered. I have worked tirelessly for this community. Working tirelessly to expand your own power, maybe, Helen Norton said. I had not noticed her slip into the courtroom, but there she was, standing beside me with her arms crossed. I have watched you and your little board turn this neighborhood into a police state. Well, it ends now. Karen stomped away, her heels clicking angrily on the courthouse floor. The local news picked up the story after the hearing. A television crew came to my house to film the fence and interview me. I gave them the short version of the story, focusing on the historical significance of the fence and the questionable expansion of HOA authority. The segment aired that evening on the local news, and suddenly my fence was famous. I started getting calls from people across California who had experienced similar problems with overreaching HOAs. A state assemblyman reached out to Gregory, expressing interest in introducing legislation to provide more protection for homeowners against HOA abuse. But the attention also brought unwanted scrutiny. A few days after the news segment, I came home to find that someone had spray-painted "scofflaw" across my fence in bright red letters. I was furious and heartbroken. The beautiful weathered wood was now defaced. I called the police and they sent an officer to take a report. The officer, a young man named Rodriguez, was sympathetic but not optimistic. Without witnesses or video footage, it is going to be hard to figure out who did this. Do you have any security cameras? No, I never thought I would need them. You might want to consider installing some. It sounds like you have made some enemies with this HOA situation. I called Gregory, and he immediately said, document everything. Take photos from every angle. This could actually help our case if we can show that the HOA or its supporters are engaging in vandalism and harassment. Over the next few days, I installed security cameras around my property and began the process of carefully cleaning the spray paint off the fence. It took hours of work with special solvents, and some of the paint had soaked into the wood grain, leaving faint stains. Every time I looked at those stains, I felt a fresh wave of anger. The case moved into discovery, which meant both sides had to turn over documents and evidence. Gregory subpoenaed all the HOA's records related to the boundary expansion, board meeting minutes, and communications with homeowners. What we found was stunning. The HOA board had discussed the boundary expansion in several closed-door meetings, but had deliberately avoided notifying affected homeowners. In one email exchange that was part of the discovery, Karen Whitmore had written to another board member, "If we notify them in advance, they will just object and tie everything up in bureaucracy. Better to expand first and deal with any complaints later. Most people will not fight back." Gregory was practically bouncing in his chair when he showed me the emails. This is gold. This shows intentional disregard for legal requirements. It is going to be very hard for them to argue that this was just an innocent mistake. We also discovered that the HOA had been fining homeowners and placing liens on properties for months before even properly recording the boundary expansion with the county. In some cases, they had collected thousands of dollars in fines from people who did not know they could fight back. "This might actually be fraud," Gregory said. "They were collecting money under false pretenses, claiming authority they did not legally have. Should we report this to the police? Let me talk to the district attorney's office. If there is a criminal case here, they should know about it." In mid-July, we finally got our full hearing date scheduled for September 15th. It seemed impossibly far away, but Gregory assured me it was actually quite fast for a civil case. Meanwhile, the fight was taking its toll on everyone involved. Helen Norton received a threatening letter from the HOA claiming she had violated some obscure rule about holiday decorations, even though it was the middle of summer and she had no decorations up. Tom and Lisa Peterson were told their mailbox needed to be replaced with an approved model that cost 3 times what a standard mailbox cost. We added these new harassment claims to our lawsuit, and the case continued to grow. What had started as a simple dispute about a fence had evolved into a full-scale battle over property rights and HOA authority. In August, I got a call from an investigator with the Riverside County District Attorney's Office. Her name was Sarah Kim, and she wanted to meet with me and Gregory to discuss the HOA's activities. We met at her office, a gray government building downtown. Sarah was in her 30s with sharp eyes and a direct manner. "I've been reviewing the documents your attorney provided, and I have some concerns about the HOA's conduct. Can you walk me through exactly what happened from the beginning?" I told her the whole story, from finding the first violation notice to the spray-painted fence to the discovery of the emails, showing deliberate avoidance of legal requirements. She took detailed notes and asked clarifying questions. "Here is the situation," she said when I finished. "Based on what I am seeing, there is a possible case for fraud and potentially theft by false pretenses. The HOA collected money from homeowners by claiming they had authority they did not legally possess. That is a crime." "What happens now?" Gregory asked. "I need to do more investigation, talk to other affected homeowners, and review the relevant statutes. But if the evidence supports what I am seeing, we may file criminal charges against the HOA board members." My stomach clenched. Criminal charges? Like, they could go to jail? Potentially, yes. If they knowingly violated the law to collect money from people, that is not just a civil dispute. That is criminal fraud. Over the next month, Sarah interviewed dozens of homeowners who had been affected by the HOA's illegal expansion. The stories were remarkably consistent. People received official-looking notices claiming they were in violation of HOA rules. They were threatened with fines and liens, and many paid up just to avoid the hassle, never knowing they could fight back. One elderly couple had paid over $8,000 in fines and fees for violations ranging from lawn height to mailbox style. When Sarah interviewed them, the wife broke down crying, explaining that they were on a fixed income and the fines had forced them to cut back on necessary medications. The week before our civil trial was scheduled to begin, Sarah Kim called with news. "We are filing criminal charges against 3 members of the HOA board, including Karen Whitmore. The charges include fraud, theft by false pretenses, and conspiracy. I felt a complicated mix of vindication and anxiety. What does this mean for our civil case? Your case will likely be stayed until the criminal proceedings are resolved. The judge will not want to interfere with an active criminal investigation. Gregory was philosophical about the delay. It is frustrating, but honestly, the criminal charges help us. If the board members are convicted, it will make our civil case even stronger. The news of the criminal charges exploded across local media. The story made the front page of the Riverside Press Enterprise, and the television stations ran it as their lead story. Karen Whitmore and 2 other board members, Robert Chen and Patricia Davis, were arrested and booked at the county jail. They were released on bail the same day, but the damage to their reputations was immediate and severe. I watched the news coverage with a strange sense of unreality. This had all started with a simple fence, and now people were facing criminal charges. Part of me felt guilty, wondering if I had somehow caused this, but then I thought about the elderly couple who had skipped medications to pay bogus fines, and the guilt evaporated. Helen Norton called me that evening. "Did you see the news?" "Yeah, I can hardly believe it." "Good riddance. Those people needed to be held accountable. They have been bullying this neighborhood for years." The criminal trial was scheduled for December. In the meantime, my life slowly started to return to some semblance of normal. The HOA, now leaderless and facing criminal charges, stopped sending violation notices. My fence stood unmolested, the spray paint stains gradually fading in the California sun. I spent more time getting to know my neighbors, and a real sense of community began to develop on Magnolia Street. We started having monthly block parties, and people looked out for each other in ways they had not when they were all worried about HOA violations. Tom and Lisa Peterson had a baby in October, a little girl they named Sophie. Helen Norton organized a neighborhood shower, and it felt good to celebrate something positive after months of legal stress. The criminal trial began on December 3rd. I attended every day, sitting in the gallery and watching as the prosecution laid out its case. Sarah Kim was thorough and methodical, presenting email after email, document after document, showing how Karen Whitmore and her co-defendants had deliberately expanded the HOA's authority without following legal procedures, then used that false authority to collect money from unsuspecting homeowners. Karen took the stand in her own defense, and it did not go well. She tried to argue that she'd been acting in good faith, believing she had the authority to expand the HOA boundaries. But under cross-examination, Sarah produced an email where Karen had explicitly acknowledged that they were skipping required procedures. "You wrote here, 'We cannot notify them in advance or they will just fight us,'" Sarah read. "That does not sound like someone who believes they are acting within their authority. That sounds like someone who knows they are breaking the rules." Karen sputtered and tried to explain, but the damage was done. The jury deliberated for 2 days. On December 20th, they returned with guilty verdicts on all major charges. Karen Whitmore, Robert Chen, and Patricia Davis were convicted of fraud and theft by false pretenses. The courtroom was silent as the verdicts were read. Karen started crying. Her previous arrogance completely evaporated. Sentencing was scheduled for February. In the meantime, the civil case was finally allowed to proceed. With the criminal convictions in hand, Gregory filed a motion for summary judgment, arguing that there was no longer any factual dispute about the HOA's illegal conduct. The hearing on the motion was held on January 15th of the following year, almost exactly 1 year after I had received that first violation notice. Judge Martinez reviewed the criminal convictions and the evidence in our civil case. Based on the criminal convictions and the undisputed evidence that the HOA expanded its boundaries without following required legal procedures, I am granting summary judgment for the plaintiffs. The HOA had no legal authority over the plaintiff properties, and all fines, liens, and violations are hereby declared null and void. Furthermore, the HOA is ordered to reimburse all affected homeowners for any fines or fees they paid, plus interest. She continued. Regarding the fence specifically, it is clear from the historical record that this structure was built in 1947, long before the HOA existed. Even if the HOA had valid authority, which they did not, This fence would be a non-conforming use entitled to protection. Mr. Lawrence is under no obligation to alter or remove his fence. I sat there feeling a wave of relief so powerful, I thought I might cry. It was over. After a year of stress and fighting and worry, it was finally over. Gregory and I walked out of the courthouse into bright January sunshine. "We did it," he said, shaking my hand. "You stood up to them, and you won." "We all won," I said, thinking of Helen and Tom and Lisa and all the other neighbors who had joined the fight. Karen Whitmore's sentencing hearing was held in February. She received 3 years in prison, though with the possibility of parole after 18 months. Robert Chen and Patricia Davis each received 2 years. The judge was harsh in his comments, noting that they had abused positions of trust and targeted vulnerable people. "You used the facade of legitimate authority to steal from your neighbors," the judge said. "This was not a simple mistake or overzealous enforcement of rules. This was deliberate, calculated fraud. Prison time is appropriate." As I sat in the courtroom watching Karen being led away in handcuffs, I felt no joy, just a quiet sense that justice had been served. The civil judgment resulted in the HOA paying out over $200,000 in restitution to affected homeowners. The organization itself was dissolved, its remaining assets distributed among those who had been wronged. My share was just over $5,000, which did not begin to cover the legal fees and stress, but it was not really about the money anyway. In March, the state assemblyman who had contacted Gregory introduced legislation creating stronger protections for homeowners against HOA overreach. The bill, dubbed the Homeowner Protection Act, required HOAs to follow strict procedures when expanding boundaries, imposed penalties for false claims of authority, and created an easier path for homeowners to challenge questionable fines. The bill passed both houses of the state legislature and was signed by the governor in September. At the signing ceremony, I was invited to stand behind the governor as he signed the bill into law. It was surreal to think that my fence had sparked legislation that would protect homeowners across California. Amanda Torres from the Press Enterprise wrote a follow-up article about the whole saga, from the initial violation notice to the criminal convictions to the new legislation. What started as one man's fight to save a historic fence became a movement that exposed systemic problems with HOA governance and led to meaningful reform, she wrote. Life on Magnolia Street gradually returned to normal, but it was a better normal than before. Without the HOA looming over everyone, people felt free to actually live in their homes. Gardens grew a little wilder, houses were painted in colors people actually liked, and mailboxes came in all shapes and sizes. Helen Norton planted a spectacular rose garden that would have gotten her fined under the old HOA rules. Tom and Lisa installed a bright blue front door that they had been wanting for years. Frank Morrison finally got to put up the flagpole he had always wanted. As for my fence, it stands exactly as it has since 1947. I had it properly restored by a historic preservation specialist who carefully repaired the damage from the spray paint and reinforced a few weak spots without altering its character. I also installed a small plaque near the gate that reads, "Built 1947, survived 2025. On warm evenings, I sit in my backyard, looking at that fence and thinking about everything that happened. Robert Fletcher, who built it with his own hands nearly 80 years ago, could never have imagined the battle his craftsmanship would spark. But I like to think he would be proud that his work not only survived, but became a symbol of standing up against unjust authority. The legal battle taught me things I never expected to learn. I learned that sometimes the right fight is worth the stress and the cost. I learned that communities become stronger when people stand together against bullies. I learned that one person taking a stand can spark change that helps thousands of others. I also learned to appreciate my neighbors in ways I had not before. Helen became one of my closest friends, someone I could call for anything. Tom and Lisa asked me to be Sophie's godfather, an honor that moved me deeply. Even Frank Morrison, who had seemed like a grumpy old man when I first moved in, turned out to be a wonderful storyteller with a sharp sense of humor once you got to know him. The story did not quite end with the court cases and legislation. About 6 months after everything was settled, I received a letter from a woman named Margaret Fletcher. She explained that she was Robert Fletcher's granddaughter and had seen the news coverage of my case. She wanted to meet me and see the house and fence her grandfather had built. We arranged for her to visit on a Saturday afternoon in October. She arrived with her husband and 2 teenage children, and I gave them a complete tour of the property. Margaret was in her 60s, with her grandfather's same careful attention to detail evident in how she examined every joint and beam of the fence. "Grandpa would have loved knowing that his fence became famous," she said, running her hand along the weathered wood. "He was so proud of this house. He built it for my grandmother after he came back from the war. He told me once that he wanted to build something that would last, something that would still be standing long after he was gone." "Well, he succeeded," I said. "And I promise you, as long as I own this house, this fence is not going anywhere." Margaret reached into her purse and pulled out an old photograph. It showed a young man in work clothes standing beside the fence, which looked new and bright in the picture. "This is Grandpa in 1947, right after he finished building it. I want you to have this." I took the photograph carefully, feeling the weight of history in my hands. "Are you sure?" "Absolutely. The fence belongs to you now, but the history belongs to both of us. I think Grandpa would want you to have it." I had the photograph professionally preserved and framed, and it now hangs in my living room, a reminder of the man who built something meant to last and the unexpected journey his craftsmanship took me on. Looking back on everything that happened, I sometimes wonder what would have occurred if I had just complied with that first violation notice. What if I had torn down the fence and built something that met the HOA's arbitrary standards? I would have saved myself a year of stress and legal battles. My picture would not have been in the newspaper, and I would not have spent countless hours in courtrooms and lawyers' offices. But I also would have let injustice stand. I would have allowed an organization with no legal authority to bully me and my neighbors. That elderly couple would still be skipping medications to pay bogus fines. Karen Whitmore would still be running her little fiefdom, drunk on the petty power of telling people what color they could paint their houses. And most importantly, a piece of history would have been destroyed. That fence, built by a young man who had survived a war and wanted to create something beautiful and lasting for his wife, would be gone, replaced by vinyl that would last maybe 20 years before starting to fall apart. In the end, the fence became about more than just wood and posts. It became a symbol of the importance of standing up for what is right, even when it is hard. It became a reminder that individuals can make a difference when they refuse to be bullied. It became proof that sometimes the old ways, the careful craftsmanship, the things built to last, are worth fighting for. Every morning I drink my coffee looking out at that fence. The wood has continued to age gracefully, taking on new character with each passing season. Birds nest in the corners where the posts meet the crossbeams. Climbing roses that I planted have begun to weave through the slats, adding color without hiding the beautiful woodwork. Neighbors walking by often stop to admire it, and I've gotten used to telling the story to curious visitors. Some of them have their own HOA horror stories, and I always listen sympathetically and offer what advice I can. Gregory has become something of a specialist in HOA cases, and I have referred dozens of people to him over the past couple of years. The legislation that came out of our case has had real impact. According to the Assemblyman's office, over 30 homeowners across California have successfully used the new protections to fight back against questionable HOA actions. Several HOAs have been forced to dissolve after being found to have exceeded their authority. The law has teeth, and HOA boards across the state have become more cautious about overreach. There are still problems, of course. HOAs serve legitimate purposes in many communities, and most are run by well-meaning people trying to maintain property values and neighborhood standards. But the law now provides a check against the Karen Whitmores of the world, the petty tyrants who use HOA rules to bully and control their neighbors. As for me, I am still living in my 1947 bungalow on Magnolia Street in Riverside, California. The house has become even more of a home than I imagined it could be. I know my neighbors. I feel connected to my community, and I wake up every day grateful for the fight I chose to take on. The fence still stands, just as it has for over 75 years. It is weathered and gray and beautiful, a testament to quality craftsmanship and the importance of standing your ground. When the evening light hits it just right, casting long shadows across my backyard, I think about Robert Fletcher and all the care he put into building something meant to last. He built better than he knew. That fence did not just last through decades of California weather. It lasted through a legal battle that exposed corruption and led to meaningful reform. It outlasted the HOA that tried to destroy it. And it will still be standing long after I am gone. A reminder that sometimes the right fight is the one worth having. I planted a tree near the fence last spring, a California oak that will grow slowly but surely, adding its own history to the property over the coming decades. In 100 years, maybe someone will stand in this yard and look at that tree and that fence and wonder about the stories they could tell. I hope whoever lives here then appreciates what they have. I hope they understand that this is not just a property, but a piece of history. And I hope if anyone ever tries to tell them to tear down that fence, they have the courage to fight back just like I did. Because some things are worth fighting for. A piece of history. The principle of standing up to bullies. The right to enjoy your property without unjust interference. These things matter, and they are worth defending. My fence is still here, standing strong after 77 years. It survived wars, economic depressions, earthquakes, wildfires, and Karen Whitmore. It is a survivor, just like all of us who fought to protect it. And every time I look at it, I smile and remember that one person standing up for what is right really can make a difference. The battle was long and difficult, but in the end, justice prevailed. The fence stands. The HOA is gone. The law has been changed, and life on Magnolia Street is better for everyone. That weathered wood fence taught me more about courage, community, and standing up for what is right than I ever expected to learn from a property feature. It connected me to history, to my neighbors, and to a larger fight for justice that impacted thousands of people across California. Sometimes I wonder what Robert Fletcher would think if he could see his fence now, famous and protected by law, a symbol of resistance against unjust authority. I think he would be pleased. He built something to last, and it has lasted in ways he never could have imagined. The fight is over now. The fence remains. And every morning when I see it standing there in the California sunshine, solid and enduring, I feel a deep sense of satisfaction. We won. Justice prevailed. And a piece of history is preserved for future generations, all because I refused to back down when faced with an unjust demand. That is the story of how my fence, built in 1947, outlasted an HOA that did not even exist until 72 years later. It is a story about standing up to bullies, fighting for what is right, and the unexpected ways that defending something simple can lead to meaningful change. And it all started with a violation notice taped to my door on an ordinary Tuesday morning in March.